Good afternoon and welcome everybody to the EU and UK Forum on the Future of Digital Regulation in the UK and Europe. For those of you who don't know me, I am Lara Stoimilova and I'm a competition and regulatory economist with 20 years of experience, and I will be moderating today's discussions. For those of you who are new to the forum has been set up to encourage a constructive and informed debate between the UK and its European neighbours on a wide area of policy areas. And it is an nonpartisan, and it's actually a platform which has been set up for information exchange, debate, and discussion. And it is in that spirit that we will be talking about the future of digital regulation today. For your information, this is a wide area of policy initiatives, and we will be focusing entirely on the European Commission Digital Markets Act and similar initiatives which are taking place in the UK and Germany. And to facilitate these discussions, we've got an excellent panel members with us today. Today we are joined by Will Heiter, who is the Senior Director of the Digital Markets Unit at the Competition and Markets Authority, which actually will oversee the implementation of these rules in the UK. We are also joined by Silke Hossenfelder, who is the head of the General Policy Division in the German Competition Authority. And last but not least, we are also joined by Alec Burnside, who is a partner with Deckard LLP and who's been very active not only on competition cases, but also on competition law reforms. Welcome, everybody. Before we start our discussions, I would like to let you know that listeners can actually talk to each other by using the chat function on your right-hand side. You can do so with other members of the forum throughout the debate, but also you can put questions to the panel members, and I will make my utmost to put those questions forward towards the last 20 to 15 minutes of our debate. In the meantime, if you need any help, information, or support, please also contact Rebecca Matheson using the same chat area. Finally, you can also keep an eye on live tweets using the Twitter tab. Now, without ado, I would like to start with our first question to the panel, which is about the scope of the regulations. As we know, the Commission's Digital Markets Act has provided a very long list of platforms which are in scope of the regulation, whilst the UK is adopting a slightly more complex approach. So my first question is to Silke. Silke, can you briefly explain the scope of the regulations that have been adopted in Germany and how they may be comparing to either the UK or the European approach?
Well, thank you very much for inviting me to this panel and joining this interesting debate. And I'm happy to introduce to you a little bit the thoughts and the specificalities of the German law, which is actually in place since January of this year. And in the course of this amendment of our competition law, we have some new provisions which focus clearly on big tech companies and the problems for competition that they create. Now, this German approach features a novel provision addressing companies with paramount significance for competition across markets. You listening to this very long sequence of words might lead to some comparables with the UK approach, and not so much in that respect with the DMA approach. We are looking at it more from a qualitative perspective, trying to catch the very specific issues that we see in these markets and with the companies we are looking at. Now, the whole new provision aims at a faster and more effective proceeding in the context of digital economy. And actually, the law has introduced a two-step procedure. In the first step, the competition authority, the Bundeskartellamt, can identify and designate such companies of paramount significance for competition across markets by decision. So this is a very pinpointed procedure. We can concentrate on those companies where we see a need to intervene. And it is quite clear from the legal context and the explanations in the memorandums of the law that we will be focusing on ecosystems of digital conglomerates. Now, in the second step, after we have designated these companies, we can activate tailored prohibitions. Now, the law contains a list of general principles with some very specific examples under these principles, which we can activate for each company where necessary. So you will find prohibitions which you may also find in the UK documents, and you will find in the DMA, like self-preferencing, envelopment strategies, or hindering of interoperability. And here the relevant, well, as I said, we've got a combination of general principles and very specific rule examples. Now, the advantage of this whole new construction is actually that we can activate prohibitions even if there is no dominance yet. Also important is to say that this German approach allows for justification by the companies, whereby the burden of proof for such facts is on the companies. It's not the authority investigating any justification issues on its own account. A final aspect that will make these procedures faster is that judicial control is focused on the Federal High Court. So there's only going to be one instance for these procedures. And all of this aims at earlier intervention and faster proceedings. That's maybe, for a start, the sketch of our system.
Thank you, Silke. Coming to you, Will, the UK is proposing to adopt a slightly different approach to the DMA. Rather than listing the services that will apply to, it has a provision to determine activities where digital technologies are a core component of the service and product to be offered. And my question to you is, how will the CMA assess this in practice? What does it mean? Digital technologies, what does it mean core component? How will you implement it in practice?
Yeah, thank you. And thank you very much for inviting me to what I'm sure will be a really interesting discussion. I have to do a little bit of housekeeping up front, which is just to make very clear that while I can speak for the CMA on some things at least, I definitely do not speak for the UK government, whose process this currently is. The government's consultation actually just closed on Friday, and it will then have its own process of thinking about the responses and working out where to go next. And the eventual framework will be subject to Parliament's decision making. So I just want to get that out of the way. So with the proposals that the Digital Markets Task Force and the CMA have put forward, and which have informed, I think, the consultation from the government, the key point is the concept of strategic market status, which is intended to be a very, very targeted and specific assessment of a particular set of activities and whether that sense of strategic market power exists in those activities. And as you say, the consultation from the government indicates that we should consider activities where digital is a core component. Now, obviously, the word digital is a very broad one, and many markets have a digital element. But we think that many of the definitions are not settled. I mean, even the much used term digital platforms, I think, would be up for debate. So the approach that's been put forward is intended to strike a balance between setting some clear parameters and allowing some flexibility to respond to newer digital business models. For example, I think we wouldn't expect that, for example, a retailer with an online presence would be covered, but a business that is clearly digital first could. But in any case, any potential remedies are always subject to this assessment of strategic market status, which is the key element. And I should say that the specifics of exactly how we will do that depend on where the government ends up through the process, what Parliament decides, and then we would expect to consult fully on the guidance around the details of that in advance of any initial assessment process over the next period.
Before moving on to Alec, well, if I may ask one more additional questions, because both you and Silke have already covered the scope of the regulation, but also how designation might work in practice. And you've talked about firms having strategic market status. And I mean, having worked for a very long time in telecoms regulation, we always think about companies which have a position of dominance and whether they would have an incentive and ability to basically abuse that dominant position. And suddenly we are referring to strategic position. And how does strategic differ or complement dominance in this particular context?
Yeah, good question. I would say that the broad sort of economic underpinnings for the different concepts are very similar, actually. I mean, what we're concerned about here is firms that have a position of market power which is unlikely to be eroded away organically anytime soon, based on the assessment we would make. The nature of the legal test, of course, is intended to be slightly different here, and that's again subject to where the process ends up. But the intention here, as elsewhere, would be to understand the nature of the competitive constraints on the business and the potential harm that could arise. The word strategic is intended to convey a sense of the particular activities being a particularly important access point for a large number of consumers, or indeed a particularly important input to a large number of other businesses' activities. And the concept of an ecosystem is also important, as I think it probably is in Germany as well.
Thank you. Alec, if I can turn to you as a practitioner in this area, we've talked about the scope of the regulations and potentially how designations might work in the UK and in Germany, and we know what the European Commission has proposed in this area. From your point of view, what are the potential advantages and, most importantly, disadvantages with the proposed approaches? What are the risks, unintended risks, which might be associated with these?
Lara, thank you. I should begin with a disclosure. And as a practitioner, I have clients, and my clients over a long period have all been very much those concerned with the activities of the digital companies and Google in particular. So forum members can take as many pinches of salt, or indeed handfuls of salt, with my comments. But it is a field that I followed over very many years, and I can't tell you how happy I am that we're now prepared for action. In the conferences that I've spoken at in the last period, it's always been a question of the mounting pile of reports about the problems, and now we're moving to action. And the question is the action right? I think my view is that the thinking motivating the action is very good and clear. I welcome, in particular, Silke's references to ecosystems and envelopment strategies, because that's been the experience that we've had over the last period. The challenges of getting the regulation right are real, and as we'll come to discuss, the coordination between different systems is a challenge, but it's a challenge that we have to face, because doing nothing is an even worse option. We know that antitrust enforcement has been, alas, ineffective. And for all of the cases that you know where the antitrust enforcement hasn't worked because the remedies haven't been well designed, for example, whatever reason, I can tell you that there's a list as long as my arm and the arms of many other practitioners in Brussels of complainants whose complaints never even got looked at. So the time for action is with us. It's good. How do we best construct a system so as to avoid unintended consequences? It needs to be fact-based, and it needs to be informed by good thinking and expertise. And out of fairness to the companies concerned, It has to ensure due process, and yet it mustn't go on forever and a day. Silke already described in the German process the limitation of the appeals so as to get to a result. I guess one side of my brain says, as a lawyer, that's not a great thing, limiting the appeals, but there is, you have to find a middle ground. The best is the enemy of the good, as the English have learned to say, imitating the French. And that imitation is there. There is considerable convergence between the different systems, which we'll come on to discuss, but that's already a good thing. The designation is the fundamental. Will is certainly not able to say who would be designated, nor is the European Commission. Silke did share with me that the designation process is underway in Germany, and I won't steal your thunder, but maybe we should let you explain that. If it should be that all of the countries designate the same companies, that's already a coherence. If we have different designations, then that is already a major dislocation between the systems, and then you get to the question of the substance of the remedies. But let me pause. That's enough from me.
Thank you, Alec. Before we move on to remedies, Silke, do you want to come in perhaps to finish off this piece by talking about the designation process or who you might be designating in Germany?
So,
if you can unmute.
there I am. Yes, well, actually, of course, this whole designation process is something that we have to develop currently. It's not as easy as the DMA system might look, where you have quantitative thresholds and then you have a result, even though even there are some qualitative aspects that the Commission will be able to take into account. We are more or less only looking at qualitative issues, of course, the quantitative ones that sustain or this kind of view as well. But actually, the law only contains a non-exhaustive list of criteria that could be looked at if you assess such a position. And among those, there are, of course, some criteria that look as very relevant for ecosystems, like the question of if the addressee has, what is the addressee's access to data relevant for competition, or what is the relevance of the company's activities for third-party access to supply and sales markets, and its related influence on the business activities of third parties. So there you find this aspect which is trying to fill in maybe what this approach of paramount significance across markets might be in the end. Now, actually, as I said, the new rules came into force in January this year, and we have started our first procedure, I think, in January, which was on the Facebook case. And in the course of the year, we have now opened designation procedures with regard to Google, Amazon, and Apple. So that's the scope we are looking at. And the procedures are ongoing. I think that's what I can say there.
No, I understand. Thank you for that, Silke. I'm sure we can kind of discuss quite a lot of different issues on the designation process itself, but in the interest of time, I'm just going to move on to the discussion of remedies. Again, although the objective of the various initiatives might be the same, at this point in time, the start point seems to be slightly different. In the case of the DMA, we've got a list of specific do's and don'ts that could be imposed on designated gatekeepers, whilst in the case of the UK and possibly Germany, there is a more principles-based approach which is being adopted. So my first question is to Will. Will, can you briefly explain the UK approach and the difference between the code of conduct, but potentially the pro-competitive interventions that might support a code of conduct?
Yeah, sure. So, as you say, there are two elements before we come to mergers, but two other elements of potential remedies that could apply to firms with strategic market status, and that's the legally enforceable code of conduct and the pro-competitive interventions. I'll start with the difference between the two as proposed. The first would be intended to manage the effects of market power, whereas the pro-competitive interventions would be intended to actually reduce the market power, go to the causes of that market power. So the code of conduct, I mean, this is one of the elements that's the specifics of which are subject to the government consultation, and there are some options around that. So when I talk, it's mainly about the version that the CMA has put forward, but that is a set of principles applying to a given SMS firm in relation to its designated activities, all of which would derive, though, from three high-level objectives that we proposed would be in the primary legislation, and those are fair trading, open choices, and trust and transparency. So the proposal was that below those high-level objectives, the specific principles that would apply would be targeted to the specifics of a particular firm and a particular set of activities. So while I think, based on the underlying thinking, we would expect to worry about the same sorts of harms, for example, that the EU is doing in the DMA, the way by which we would arrive at the specific rules would be different in the UK proposed process. And the pro-competitive interventions, again, would be expected to be very targeted, following a specific investigation. If a firm had SMS, one could then do a pro-competitive intervention process, and at the end of that, having identified a particular problem, we'd put in place a specific remedy to address that problem. And that, I mean, there are various such remedies that have been talked about, but often those might be things to do with data access. We talked about a number of possibilities in our online advertising market study, but of the things of the likes of interoperability, for example, it'd be one good one.
Thank you. And one thing which, and one observation I had is that one of the CMA's proposals was, before you impose a pro-competitive intervention, whatever investigation you do, you look at the effects on competition, but also consumers. And what I wanted to understand was what was the rationale behind specifying the test to include both effects on competition and consumers? And would there be, for example, harms which are not being addressed if the test is not implemented in that manner, ultimately?
Yeah, so as you say, the Digital Markets Task Force put forward this adverse effect on consumers and competition test. And the idea behind that was to ensure that the new regime could address consumer harm without always necessarily needing to show that competition had been undermined. The proposal in the consultation, however, is essentially not to introduce the extra C, but just to leave the adverse effects on competition test. Now, actually, in practice, we're quite relaxed about that. That's the test that currently applies in our market investigation regime, and we still expect that test, for example, to be able to allow us to intervene potentially to give consumers more choice over their data, for example, with the aim of improving competition. So, as I said, it's a very familiar test in its current form. And we're content with that being the way forward.
Thank you. Silke, how does your proposed approach compare to either the European proposals or UK, or differ? Is there anything new that we could add perhaps into the proposals?
Well, I think actually that the UK proposal is rather sophisticated. With regard to comparing, sorry, what's?
I think there is a little bit of feedback loop, but don't worry.
Okay, I'll just go on. I think there is some aspects of our approach that's more similar to the UK approach, and others that have similarities also to the DMA approach. So what's comparable to the DMA approach is that we actually have some very clear and specific rule examples for the companies that we will be designating that they may have to follow. And I think that in the UK approach, there is not such a very clear, specific example in the law or in the coming law. That's my understanding. So there we have some comparabilities, comparable things to the EU approach. However, what is more comparable to the UK approach is that we always felt having only specific examples is not really enough, because digital markets are very, very dynamic, and we also see that the examples also in the DMA, the prohibitions, are very much based on case law, and that is past case law, of course, not upcoming case law. And we wanted to be very clear, to have the possibility with some more general principles to be able to pick up things that have not been put in place yet. Like if we talk about self-preferencing, for example, there are many different ways to do that. And it's, if you have a draft that says you're not allowed to present your own offers in a more favorable way, then that's only a little bit of self-preferencing. Companies might just find other ways of self-preferencing. So in our law, you will find a general prohibition on self-preferencing with a specific example for self-preferencing in presenting its own offers. That's a bit the functioning of our law. And in that respect, it is, I guess, more similar to the UK approach. On the other hand, what we don't have, and I'm not quite sure yet if I'm very interested in to see how the UK colleagues are going to deal with that, is we don't have something which is comparable to the code of conduct approach of the UK approach, because that aims, and I understand why you would want to have them, but it looks to me like something where you aim at solving very many problems at once or at the same time. You look for a complete solution. Maybe I'm wrong, Will, you'll have to explain to me. And I think that our focus in that respect might be a bit more competition law-like, in the sense that you just pick up cases, pick up conduct of companies as there is a need to do so. And that's also the idea a bit behind the competition authority activating these prohibitions for the designated companies.
Thank you, Silke. Before I move on to Alec, Will, would you like to respond to Silke at all, or is her understanding?
Yeah,
correct?
It's maybe not so different after all. I suspect is probably my take. In that, so the way that the way we propose the code of conduct is those three high-level objectives would appear in the legislation, but any code of conduct would only go so far as necessary for the particular strategic market status that had been identified in the particular set of activities by the particular firm. Mm-hmm. So in that respect, I think very much intended to be highly proportionate, highly targeted at exactly where we see the issues. So certainly not the case that there will be the same set of rules applying to every SMS firm across every related activity.
Thank you, Will. Coming to you, Alec, we've already heard both Will and Silke say that in some cases, the interventions which are put in place may include things like data interventions, interoperability, etc. And my concern is that obviously there is a high risk that such interventions might actually overlap with other interventions which are already out there. For example, one might impose interoperability obligations, but there may be an issue with security obligations imposed on the same firm. There may be data obligations, but on the other hand, consumers might worry about their own security and confidentiality. So how should competition authorities go about dealing with these kind of opposing constraints and opposing requirements?
Lara, allow me to spend just a moment first on the generality, because we've had an interesting exchange and convergence between the UK and Germany, but we haven't talked so much about the European system. As Silke reflects, the European system at the moment is based on case law, or I wouldn't actually put it that way. It's based more on concerns that never actually got as far as a decision. They were failed unsuccessful antitrust initiatives, and now you're taking the legislative tool to deal with those problems. But it's very much, as written in the Commission's proposal, a set of defined problems without the agility to adapt. And the agility to adapt is what Will and Silke have in their systems, and it's what the European system would obtain, at least under the proposal which was launched only recently from Germany, but not from the Bundeskartellamt, from the ministry, together with counterparts in France and the Netherlands, I believe, doubling themselves even the friends of the DMA.
Friends of effective DMA, Alec.
Of effective DMA. Thank you. Yes, very good. I see it here. And I think that will bring the European system to convergence with the UK and the German approach, and that's to be welcome. If the antitrust enforcement efforts of the last period have shown us anything, it's that the digital companies know their markets better and are more agile than the antitrust authorities, and the agencies are going to have to build up that expertise and be as agile. That's what we're talking about here. The question of coordination with other regimes, of course, is a very good one. Again, it's a counsel of despair to say, well, it's going to be a clash, so we shouldn't do it. You just have to find an accommodation, and there has to be dialogue between regulators. That dialogue between the antitrust authorities and the data protection agencies has been brewing for a while, but now it's happening. Silke, you have your famous case against Facebook, where the standards of the GDPR had been used as a benchmark for identifying an antitrust infringement. That's good. It's a process. The expansion of antitrust over the years has given us this issue many, many times over. Simply within merger control, we started out when the merger regulation was new with 3 or 4, maybe 5 countries in the world practicing merger control. We now have 100. And we have the International Competition Network where the agencies meet and try to align on good practice. It's hard work and it's a long haul, but it has to be done. But the points of interaction are real. And just to give one to help solidify this for those listening, the GDPR is obviously an important protection, and the digital client companies implement it. But actually, implementing it has been done in a way that actually reinforces dominance. It's called weaponization of privacy, and there are complaints pending in that respect. So dialogue, well-formed ideas between the agencies, that's the best one can say. I did have a question for Will, if I might. You saw me wagging my pen before I had wanted to come on with the question of competition and consumers, but not just consumers, well, also citizens. Because there was a point in your advice that the new system should protect us as citizens rather than consumers, and the government hasn't gone with that, which for myself I rather regret. I mean, I don't ask you what you think since you're bound, but I mean, at least to discuss the distinction between the two, I'm not sure that I see a distinction. If you remember that competition is meant to protect values not only of price but also of quality. We know from the Bible that man does not live by bread alone. Protecting some of the spiritual values that we would want as citizens, free press, democratic values, and so on, it seems to me entirely legitimate that the system of regulation should look at those. And we know that the digital ecosystems have deep, far-reaching effects on us as citizens beyond simply consumption.
Well, do you want to come in?
Sure, and I'll actually bring together that question with your question, Lara. I think the two are closely related. I mean, on the consumers and citizens point, yes, as you say, Alec, our task force advice put forward the idea that the digital markets unit's objective ought to include the concept of citizens, and that's not in the government's consultation. I mean, as it happens, Ofcom has both citizens and consumers in its objectives, and that I think is to do with exactly some of those issues you describe, issues of media plurality and so on, where someone may not necessarily be a direct consumer of a service, but may be affected by its broader knock-on effects on society. In terms of the DMU, I think the important thing we felt was for the DMU to be focused on competition. That's its raison d'etre, if you like. But for example, but not to be blinkered to other broader public policy objectives. Exactly how that's allowed to happen, I think is subject to the process over the next months. But as I said, that was the intention behind that, and I think there are probably a number of different ways of achieving that objective. We're trying to achieve at least some of that objective at the moment, to the best of our ability. And I wanted to just mention a couple of things there. One is the snappily titled Digital Regulation Cooperation Forum, which is us as the CMA, our Information Commissioner, Ofcom, and our Financial Conduct Authority. And that is exactly with the intention of creating the environment for the kind of dialogue that I think you were supporting. And I would agree with your sort of skepticism about the Council of Despair that says these objectives are inevitably in conflict, because one of the most specific things we've done so far through that DRCF is produce a joint statement between us at the CMA and the Information Commissioner's Office here in the UK about the interaction between competition and data protection. And I think one of the main conclusions of that piece of work was that in many cases they can be very well aligned, in that in order to achieve good privacy outcomes and in order to achieve good competition outcomes, you need people that are able to make informed choices about the services they're using and how they use them. And that's come out even more specifically in our current case in relation to Google's plan to remove third-party cookies from Chrome, so the so-called privacy sandbox, where we're in the process of, we've been consulting on commitments from Google with proposals for them for how to make the changes they want to make, but do so in a way that doesn't create the kind of anti-competitive harms that we thought it might. And that again has been done very jointly with the ICO, lots of input to make sure that we can recognize the underlying privacy objective, but not allow that to be used as an excuse to create these kind of anti-competitive harms.
Thank you for that, Will. Now I would like to move to the area of mergers. It's kind of one of the areas which I'm kind of personally quite interested, and perhaps where currently the proposals seem to be quite different. Whilst for obvious reasons, the Commission's Digital Market Act has done very few options on revising the merger framework, which is kind of applicable in Europe. The UK has actually put forward, or the CMA has put forward quite a few proposals to try and amend the merger regime, which will apply to SMS firms. And we all know the main reason behind that is to kind of make sure that we are able to foster a truly competitive market and make sure that issues such as killer acquisitions or reverse killer acquisitions we are able to address those. One of the proposals in the UK system is that to be able to address this, one will need to change the threshold at which the CMA can intervene in phase 2 mergers by lowering actually the probability threshold. And I personally have a concern here that by doing this, we might give rise to some serious unintended consequences. For example, the risk of distortion with other parts of the UK economy, which may be relying quite heavily on digital technologies themselves, but perhaps do not get captured by the actual new rules to be put in place. And Will, my first question is to you. Can you kind of explain a little bit more the rationale behind the changes to this test and how you might address some of the potential unintended consequences?
Yes, of course. Thank you. I mean, I think we'd all recognise that as a forward-looking discipline, merger control is always something of a balance between sort of striking a balance between over and under enforcement over time. And I think there are widely held concerns about historic under enforcement in mergers in these digital markets, and that's not just in the UK, but in the rest of the world and in the various reports that we're also familiar with. And there's a increasing body of evidence that the lack of competition in activities dominated by the biggest firms makes it harder for rivals to enter and compete. And you can also see, I think, that mergers and acquisitions are a really important part of the business model of some of the most powerful digital firms. If you look at some of the strategic acquisitions they've made to reinforce an existing strong position or to extend a position into adjacent markets. So, and in many cases, the firms are acquiring targets that are at a very early stage of their development compared to, I think, what we would have seen in other markets in the past, which does make it very difficult for competition authorities to assess whether and how the acquired firm is likely to develop into a competitor. And it's that worry that underlies the proposed change to amend the phase 2 threshold for digital mergers. Rather than creating market distortions, we'd expect a balanced approach to merger enforcement in digital markets to enhance competition and innovation in the UK. And referring back to that balance between under and over enforcement over time, this is something which we think just allows that extra level of caution in relation to digital mergers to try and protect some of those nascent potential competitors. That doesn't, of course, mean that under the new arrangements, proposed new arrangements, suddenly all mergers by SMS firms are stopped. Indeed, recent evidence shows that for at least one firm that probably many people consider as a decent candidate for having SMS, we just allowed a merger through, and that's the Facebook customer merger, which was cleared last week.
Thank you, Will. Silke, are there any initiatives in the area of mergers from the German Competition Authority? Can you take us through your thinking in this area?
Yes, well, I think we are not currently on the same path as the UK colleagues here, which is not to say that there is no discussion on these issues in Germany, but there is not a real proposal or anything like that currently in the discussion. In this last amendment of our law, we have been thinking about whether or not to do something in this direction, directing merger control more at digital mergers and also looking at the tests. And we and it was then decided not to propose this. Let's put it that way. Of course, different from the UK currently, we are in the EU system, and you might think that these kind of mergers will very often go to the Commission level anyhow. Maybe they are well placed to deal with these kind of mergers as well. So this is, I think, a bit the scenario that was the situation at the time of the amendment. And on top, we have this new approach from the last amendment with the transaction value a threshold that we have introduced that tried to at least cope with the fact that many of these mergers do not fulfill the normal turnover thresholds that merger control very often works with. But and we have this test. We have some experience with it, but not too much. I don't think that it has totally fulfilled the expectations put in it. But the ministry and felt that it was necessary to just look a little bit longer into the praxis with this new threshold and see what might be possible or what kind of debates might be developing at European level.
Thank you. Alec, what is your view as a practitioner for the changes which are being proposed in the UK on merger control?
I think the changes are well conceived. I would like Lara to spend a moment on what's happening at the European level on mergers, since we don't have anyone speaking for the European system. The European Commission is trying to do something really quite similar to what Will is trying to do, but it's not actually putting its hand up and admitting it. If that's not too provocative a way of saying it. The proposal, the DMA, is under a different legislative base than would be needed to amend the merger regulation for the European Commission to do directly what Will is indeed doing directly by legislation, or Her Majesty is proposing to do. The European the DMA, as proposed, will have an obligation on the designated companies to file information that they're making an acquisition, but that's not filing the merger. The trick is that the European Commission has reinvented and reinterpreted an old power that everyone thought was more or less irrelevant. The old Dutch clause under the merger regulation, allowing it to try and sweep in cases that are not otherwise notifiable to it, and indeed the changes, cases that are so small they're not even notifiable at the national level. Now isn't the time to go on to an extended harangue about why that is a slightly slippery approach with the interpretation of the law, but it's causing quite some controversy in my circles, at least. It does, from a policy enforcement point of view, have the advantage that it will bring more cases of this kind into under control. That's from the public enforcement point of view. What do I think of it as a practitioner? Well, that really depends whether the client whose interests I might be defending is the one trying to make the acquisition, or trying to prevent the acquisition. And from that point of view, I come at this even-handedly. So if I just give you a personal opinion born of all the things that I've experienced, I think it is a good initiative to bring these digital mergers, the killer acquisitions, into review. What should the process be? That goes to the question of the phase 2 level of proof. Experience is that it is difficult to get to the result whatever everyone feels keenly is appropriate. Flexing just the level of decision at the end of a phase 2 decision, but not beforehand, seems to me to be a decent, measured approach to the thing, and it will still always be under review of the courts. So, as I said before, the best is the enemy of the good. It seems to me that this is a well-reflected and balanced proposal.
Thank you. And if I can perhaps kind of push on this point a little bit more, I mean, we've always talked about leveling the field for the users of the digital technology companies and kind of changing the merger regulation framework to try and facilitate that. But are we at all concerned what the implications of the new merger control might be, for example, on entrepreneurial spirit? If I had a company, a novel company, what I want to do is to sell it to the highest bidder, and that's what I would want to achieve at the end of the day. With all due respect, competition law is going to be the last thing in my mind, or the DMU or the DMA. And don't we risk potentially killing entrepreneurial spirit, or the spirit chilling innovation, because we will end up with so much potential regulation? You know, I'm an innovative company. I know that one day if I grow too big, I'm going to be penalized for it. Just being a little bit provocative here, apologies, but I thought perhaps putting it another way might...
well, if that's addressed to me, I mean, the argument that I hear coming from the Google camp in various is in a slightly different form. It's to say it's the business model of people in a garage in Silicon Valley to build something that Google will want to buy. And if you don't let us buy it at the end, then they won't set out on their adventure in the first place. I'm not in venture capital. I don't know that firsthand, but I don't think that the spirit of invention is dependent on that. And the startups are not going to choose not to start up for fear that they might one day have SMS status or cross-market significance. That would be a nice problem to have. That wouldn't deter me at the very beginning.
Yes.
Thank you. Silke, Will, do you want to
Yes.
come into this?
I think I very much agree with Alec on this. I mean, the intention of all these new rules and approaches that we are discussing is actually to in the end, to create more business opportunity for startup companies, maybe beyond being bought by one of the large ones, but staying in the market and becoming a valued company offering services to users, end users, business users, whatever. So, and what we perceive is that without doing anything, these opportunities will not be there. So I think on the whole, even though here and there a startup only becoming active because it thinks of selling its business might have some drawbacks from all of this, but on the whole, I think the business opportunities are going to grow for these kind of companies.
Well,
thank you. Alec and Silke have put it this very well already. But I think all of these frameworks actually, and particularly the proposals here in the UK, this is all about, it's intended to be all about innovation and all about supporting strong competition and the innovation benefits that brings. So the talk is always about exit routes for startups. And as Alec has touched on, we don't really buy the idea that these sorts of proposals kill off this sense of an exit route. And indeed, it shouldn't be the case that SMS firms, or however they're called, could be the only exit route for a startup anyway. But I think about the prospect of being bought by one of the biggest platforms and the effect of that on 3 different groups. So obviously for the potential target, being bought by one of the big platforms is a very attractive payday. But what that means is that all the incentives on such startups are to innovate in a way that's a complement to the big platforms and a nice, neat add-on to their existing businesses, rather than mounting a more direct challenge to one of their core areas of business, which is what we'd rather see. So that incentive isn't good for consumers. Then think about other possible startups perhaps in a similar market. Seeing a fellow smaller firm getting snapped up is also likely to put them off from innovating in a way that could challenge the big firm as well. Also not good for consumers. And actually, even for the potential acquirer, if they know that merger control is weak and they can cut off potential competitive threats by buying them, that weakens the drive for them to innovate. So guess what? That's not good for consumers either. Broadly speaking, if it's the big platforms that are setting the parameters of competition and innovation through their acquisition and other strategies, we won't get the best long-term results for consumers.
Thank you. I'll stop there on merger control. I'm conscious about time. The one thing I would like to ask, the one final question is for Will and Silke on organizational capacity. Now, the UK has gone down the route of setting up the Digital Markets Unit. Will, can you tell us anything about what that means in terms of organizational capacity? How big will the DMU be? How will the decisions be taken, etc.? Very, very briefly, if possible.
It'll be very brief because you won't get a very good answer. In that it really is all subject to where the legislation ends up. If it's one type of system, then it's potentially quite a small team. If it's more, it's a bigger team. Different types of skills needed to different degrees, depending on exactly how it turns out. I mean, we know some things we know, which is we need to build the expertise in these markets, which we've already been trying to do through the market studies that we've been doing, and also the assembly of our data and technology analytics team. So we know we need more of that kind of strength and capacity as we're contemplating these markets. But beyond that, lots of this is still in the detail of how the process ends up.
And Silke, have you actually increased your capacity in Germany to be able to implement your new framework?
Of course, we're also always increasing our capacity in the sense that we're getting better or trying to get better. We are adapting as organization to the whole digital development in all its aspects. We have a new unit dealing with digital economy in my division, backing the case handling units. We have a very good experience with mixed teams for conceptual work on digital issues, combining case handler experience and tech experts that we've been doing in the last years. And what we are also now trying to do, Will already talked about something comparable in the UK, is that we are cooperating with other national institutions with tech know-how, like that we have now a cooperation with the Federal Office for Information Security. That's a very specific aspect, but an issue that we will also have to deal with. Security issues, of course, could be a justification for some kind of conduct. So, and on the whole, we're reshuffling responsibilities between our case handling units. For example, we have now one division that is dealing predominantly with e-commerce issues. So you see, there is a lot of lot of movement going on. I guess we could always need a few more capacities, but
Thank you.
We hope to get them in the course of time.
Thank you very much. Unfortunately, we've come almost to the end of our session, and I can't believe that because I had a lot more questions, and also the panel had some questions to put to you, but unfortunately we've come to the end. I would like to take the last couple of minutes to just basically thank all of our panel members for giving up their time and joining us in these conversations. For you listeners, I hope you have found the session helpful and informative and constructive. For your information, the replays of today's sessions will be sent to the forum members at the end of today, and also will be uploaded to the forum website on Thursday. And obviously, if you have any additional questions or observations, please do not hesitate in reaching out to Rebecca Matheson or other members of the forum, and we'll try and come back to you as soon as possible. And I guess in the last 2 minutes, what I would like to say is thank you, everybody, for attending today's session, and stay well. And we very much hope to see you in person shortly. Thank you.
Thank you. Thank you.